before becoming one of the most controversial figures of modern history. Jeffrey Epstein was almost completely unknown. He was born in 1953 in Brooklyn, New York, into a middle-class family. There were no powerful political connections, no inherited fortune, no clear indication that this man would one day be associated with presidents, billionaires, royalty, and some of the most influential people in the world. In his early years, Epstein didn't stand out as someone destined for power. He was considered intelligent, particularly in mathematics, but nothing suggested brilliance or fame. Still, he managed something unusual. In his early 20s, without completing a college degree, he was hired to teach at an elite private school. That school was the Dalton School, one of the most prestigious institutions in New York, attended by the children of extremely wealthy and influential families. This detail matters because Dalton was Epstein's first real exposure to the world of serious money and power. Not as a guest, but as someone inside the environment, quietly observing how wealthy families thought, spoke, and operated. Not long after, Epstein was fired. There was no public scandal, no official explanation that fully made sense. His teaching career simply ended abruptly, and from that point forward, his life takes a turn that, even today, raises more questions than answers. Despite having no formal background in finance, Epstein suddenly appears working at Bear Stearns, one of the most powerful investment banks on Wall Street at the time. How he got that job has never been fully explained. Who recommended him, who vouched for him, and why an elite financial institution trusted him. Those details remain unclear. At Bear Stearns, Epstein wasn't just another junior employee. He worked closely with ultra-wealthy clients, handling complex financial strategies involving asset protection, tax optimization, and large-scale money movement. All of this without a publicly verifiable source of income that matched that level of wealth. At the same time, Epstein began moving through the highest levels of global society. He was seen alongside powerful politicians, influential scientists, and academics, major financial figures, members of international royalty, not as someone asking for access, but as someone who already belonged there. That raised a question many would ask later, but few dared to ask at the time. What exactly did Jeffrey Epstein provide that made him so valuable to so many powerful people? He wasn't a famous investor. He wasn't a public intellectual. He wasn't a visible business leader. Yet doors opened for him everywhere. Alongside this rise in status, patterns in his personal life began to emerge. Epstein was frequently surrounded by very young girls. Some were teenagers. Others appeared even younger. At the time, this behavior didn't trigger immediate public outrage. Some dismissed it as eccentric behavior from a wealthy man. Others simply looked away. But in hindsight, those moments stand out as early warning signs. For years, Epstein managed to keep a low public profile. He avoided media attention. He rarely gave interviews. He stayed out of headlines. He existed almost like a shadow. Enormously powerful, extremely wealthy, yet largely unknown to the general public. And that may have been his greatest advantage. Because while very few people truly knew who Jeffrey Epstein was, he knew exactly who everyone else was. And that knowledge would later become central to one of the most disturbing criminal cases of our time. For years, Jeffrey Epstein's wealth created a protective barrier around him. He lived openly in Palm Beach, Florida, one of the wealthiest and most exclusive areas in the United States. His mansion was well known. So were his parties, his staff, and his constant movement of people in and out of the property. Yet, very little attention was paid to who those people were. Most of the girls who would later accuse Epstein came from ordinary backgrounds. Some lived in Palm Beach County. Others came from nearby working-class neighborhoods. They were not part of Epstein's world, and that difference in status was essential to how the system worked. The recruitment usually began in simple ways. A girl would be approached outside school. at a shopping center through a friend who had already been inside Epstein's house. The offer was presented carefully. A massage, no sexual language, no obvious crime. The payment, however, stood out. $200, sometimes more. For a teenager, especially one with financial difficulties, that amount was hard to ignore. When the girls arrived at Epstein's Palm Beach mansion, they were often greeted by staff. They were taken inside. The environment was quiet, controlled, and intimidating. Once inside a private room, the situation changed. According to multiple victims, Epstein would begin by explaining rules. Clothes would come off. The massage would quickly turn sexual. Many girls later said they felt frozen. They didn't know how to react. They didn't feel they had the power to leave. Some described Epstein as calm, methodical, and deliberate, as if this routine had been repeated countless times before. And in many cases it had. Afterward, the girls were paid in cash. Before leaving, some were given instructions. They were told they could earn more money if they brought friends. Girls their own age. Girls they trusted. This is how the system expanded. There was no need for advertising. No need for public recruitment. The network grew quietly through personal connections. By the early 2000s, this pattern had repeated dozens of times. And still, nothing happened. Until 2005. That year, the parents of a 14-year-old girl contacted the Palm Beach Police Department. Their daughter had described her experience at Epstein's house in detail. Unlike previous complaints, this one triggered a deeper response. Detectives began interviewing other girls whose names appeared repeatedly. What they found was alarming. The stories matched, not just in general terms, but in specific details. The same rooms, the same amounts of money, the same instructions, the same uncomfortable escalation. Police realized they were not dealing with isolated incidents. They were looking at a pattern of systematic abuse. Palm Beach detectives compiled evidence, gathered witness statements, and identified multiple victims. By their own assessment, the case was strong enough to support serious felony charges. But that's when the case stopped behaving like a normal criminal investigation. Instead of moving quickly toward arrest, the process slowed. The case was transferred. Federal prosecutors became involved. High-powered defense attorneys entered the picture. Behind the scenes, negotiations began. Many of the victims were never informed about these discussions. Some believed the investigation was still ongoing, unaware that decisions were already being made without them. From the outside, Epstein's life didn't change. He was not detained. He continued traveling. He continued hosting guests. He continued living as a free man. And that contrast was impossible to ignore. A growing pile of testimony on one side, complete freedom on the other. This was the moment when it became clear that Jeffrey Epstein was not just facing accusations. He was protected by something far stronger than silence. Power, and the consequences of that. Protection would soon become impossible to hide. By 2007, the case against Jeffrey Epstein was no longer small. Palm Beach police had gathered testimony from multiple victims. Detectives believed they had enough evidence to charge Epstein with serious felonies related to the sexual abuse of minors. Under normal circumstances, the next step would have been clear: arrest, prosecution, and a public trial. That didn't happen. Instead, the case moved away from local authorities and into the hands of federal prosecutors. This shift changed everything. At the center of the federal case was the U.S. Attorney's Office in South Florida, led at the time by Alexander Acosta. Behind closed doors, negotiations began between Epstein's legal team and federal prosecutors. Epstein's lawyers were not ordinary defense attorneys. They were some of the most powerful and well-connected lawyers in the United States. Their strategy was simple: avoid federal charges at all costs, because federal prosecution would have meant long prison sentences, public exposure, and a full examination of Epstein's network. What followed was one of the most controversial legal agreements in modern American history. In 2008, Epstein was offered a non-prosecution agreement, often referred to as an NPA. The terms were extraordinary. Epstein would plead guilty to state-level charges, not federal ones. Specifically, he pleaded guilty to solicitation of prostitution, including involving a minor. In exchange, federal prosecutors agreed not to prosecute him federally. Not only that, the agreement also granted immunity to potential co-conspirators, even if their names were not publicly identified. This single clause would later cause outrage, because it meant that anyone who helped Epstein, knowingly or unknowingly, could potentially be shielded from prosecution. Even more disturbing was how the victims were treated. Under U.S. law, crime victims have the right to be informed about major developments in their case. They have the right to know when plea deals are being negotiated. In Epstein's case, many of the victims were never told. While negotiations were happening, some victims were led to believe the investigation was still active. They did not know that a deal was already being finalized. When the agreement was signed, it happened quietly. No press conference, no public explanation, no acknowledgement of the scale of the abuse. Epstein was sentenced to 18 months in a county jail. But even that sentence came with conditions that shocked the public once they became known. Epstein was allowed to leave jail 6 days a week for up to 12 hours a day. Officially, this was described as a work release program. In practice, Epstein returned to his office, lived a relatively normal life, and maintained access to his wealth and contacts. At night, he returned to jail. To many observers, it barely resembled punishment. While Epstein served this sentence, the broader story remained hidden. There was no trial, no public testimony from victims, no exposure of how the system operated or who might have been involved. The deal effectively sealed the case. For years, Epstein completed his sentence in 2009 and was released. As part of the plea agreement, he was required to register as a sex offender. But beyond that, the consequences were minimal. He regained his freedom. He regained his mobility. He regained his influence. And perhaps most importantly, he regained his silence. For a long time, the non-prosecution agreement remained largely unknown to the public. It wasn't until years later that journalists and legal experts began to fully examine what had happened. When they did, the reaction was immediate and intense. Legal scholars questioned how such an agreement could exist. Victims' rights advocates argued that the deal violated federal law. Former prosecutors described it as unprecedented. The question everyone asked was simple. How did Jeffrey Epstein manage to secure a deal that no ordinary defendant could ever obtain? The answer pointed back to power, money, connections, access to people who mattered. The deal didn't just protect Epstein. It protected the system around him. And that protection came at a cost, because by avoiding a public trial, the truth stayed buried. The victims were denied justice, and Epstein was given time to rebuild his life, time to continue operating in elite circles, and time that would later prove devastating. The 2008 agreement was not the end of the Epstein case. It was the pause button, and when the case returned years later, it would return with far greater force and far greater consequences. When Jeffrey Epstein was released from custody in 2009, there was no public moment that signaled closure. No press conference, no institutional reckoning, no explanation that matched the scale of what had happened. His case did not end. It simply faded from view. For the legal system, Epstein had been processed. For the public, he had disappeared. For the victims, nothing had been resolved. Officially, Epstein had been convicted of soliciting prostitution from a minor. In practice, the sentence he served was already controversial. During his incarceration, he had been granted a work release arrangement that allowed him to leave jail for most of the day, 6 days a week, returning only to sleep. By the time he walked free, the punishment had long since lost its symbolic weight. What followed after 2009 is one of the most revealing phases of the entire Epstein case. Not because of dramatic events, but because of how normal everything appeared to be. Epstein returned almost immediately to the life he had lived before his arrest. He resumed residence at his multiple properties, including his Manhattan townhouse and his private island in the U.S. Virgin Islands. His private jets were back in operation. His staff returned to work. His financial structures remained intact. There was no visible collapse, no enforced isolation, no retreat from elite spaces. To an outside observer, it looked less like a man re-entering society after conviction and more like someone returning from temporary inconvenience. This period matters because it exposes a fundamental weakness in how accountability functions when wealth and legal insulation are involved. Epstein was, on paper, a registered sex offender, but the classification imposed few real limitations on his movements, associations, or access to resources. There was no sustained oversight, no public accounting of risk, no coordinated effort to monitor his behavior. Instead, responsibility dissolved into administrative ambiguity. Local authorities assumed the matter had been handled federally. Federal authorities treated the case as closed due to the 2008 non-prosecution agreement. Civil institutions lacked both incentive and leverage to intervene. What remained was a vacuum, and Epstein operated comfortably inside it. The non-prosecution agreement itself continued to shape everything that followed. Though often described as a plea deal, it functioned more like a legal shield. Not only did it prevent federal prosecutors from bringing charges related to the same conduct, it also extended protection to unnamed potential co-conspirators. This clause would later become one of the most controversial elements of the case. At the time, however, it served a quieter purpose. It discouraged scrutiny. Anyone attempting to reopen the case faced immediate legal resistance. Prosecutors cited jurisdictional barriers. Attorneys referenced prior agreements. Institutions deferred responsibility. The effect was cumulative, not a single denial, but a pattern of deflection. During these years, Epstein maintained relationships that suggested continued proximity to power. He attended private gatherings. He traveled internationally. He remained a presence in circles that had not publicly disowned him. This continuity raises a question that is uncomfortable but necessary. How does someone convicted of crimes involving minors retain access to elite environments without sustained challenge? The answer lies not in secrecy, but in normalization. Epstein was rarely introduced as a criminal. He was framed as a controversial figure, a disgraced financier, someone who had served his time. The language softened the reality. The crime was reduced to an incident. The pattern was erased. Meanwhile, for the victims, the consequences were ongoing. Many of the young women who had been abused were never consulted during the plea negotiations that shaped Epstein's outcome. Some learned about the deal only after it had been finalized. Others were pressured into silence through settlements and non-disclosure agreements. Their stories did not disappear, they were buried. Between 2009 and 2012, civil lawsuits emerged sporadically. These cases were not coordinated, and they did not attract widespread attention. They unfolded slowly, constrained by procedural hurdles and financial asymmetry. Epstein's legal strategy during this time was consistent and effective. He relied on high-powered attorneys, aggressive motions, and prolonged delays. The objective was not necessarily to win every argument, but to exhaust opposition. And it worked. Litigation dragged on for years. Documents remained sealed. Depositions were restricted. Public access to details was minimal. For major media outlets, the lack of new criminal charges made the story appear stagnant. This was not an absence of information. It was an absence of momentum. Journalists who attempted to revisit the case often encountered institutional resistance. Records requests stalled. Officials declined comment. Prosecutors cited closed files. Without a triggering event, there was little incentive for sustained coverage. Epstein understood this environment well. He did not hide. He did not flee. He remained visible enough to signal confidence, but insulated enough to avoid scrutiny. His behavior suggested someone who believed the legal chapter of his life was permanently closed. And for several years, he was correct. This period is often skipped in retrospective narratives, treated as dead time between scandal and resurgence. But it is here, in the quiet years, that the true failure of accountability becomes clear. Nothing forced Epstein to change. Nothing required institutions to explain themselves. Nothing compelled society to confront what had happened. The system did not break dramatically. It simply moved on. By the early 2010s, the case had settled into obscurity. Epstein was no longer front-page news. His name surfaced occasionally, usually stripped of context. The victims were absent from the conversation entirely. But beneath the surface, the story was not over. Legal challenges were still alive. Documents were accumulating, and a small number of journalists were beginning to question why a case of this magnitude had ended so quietly. That pressure had not yet reached critical mass, but it was building. By the early 2010s, Jeffrey Epstein's name had largely vanished from public discussion. The criminal case was considered resolved. Media attention had moved on. For institutions, there was nothing left to address. But outside the criminal system, a different process was unfolding, slower, fragmented, and far less visible. Civil litigation was quietly reopening questions that the justice system had avoided. Unlike criminal cases, civil lawsuits did not require prosecutors to act. They did not depend on political will or institutional consensus. They relied on individuals, victims, choosing to speak, often at significant personal cost. This distinction mattered. One of those individuals was Virginia Giuffre. Giuffre's allegations were not limited to Epstein alone. She claimed that, as a minor, she had been recruited, groomed, and trafficked by Epstein and his longtime associate, Ghislaine Maxwell. According to her account, Epstein was not operating in isolation. He was part of a system that exploited access, money, and influence. For years, these claims existed largely outside mainstream coverage. They circulated in court filings, depositions, and sealed documents, visible to lawyers, but not to the public. That began to change around 2014. Giuffre filed a defamation lawsuit against Maxwell, alleging that Maxwell had publicly called her a liar. The legal strategy behind this case was deliberate. Defamation law shifted the burden. Instead of proving abuse beyond a reasonable doubt, Giuffre needed to demonstrate that Maxwell's statements were false and damaging. To do that, evidence had to surface. Depositions were taken. Documents were exchanged. Names appeared in sworn testimony. Flight records, emails, and personal accounts began to form a clearer picture of Epstein's operations and social network. Many of these materials remained sealed at first, but their existence alone signaled something important. The case was no longer dormant. It was evolving. At the same time, Epstein continued to rely on the same defensive posture he had used for years. His attorneys sought to limit discovery. They argued jurisdiction. They invoked the 2008 non-prosecution agreement whenever possible. That agreement, once again, functioned as a barrier. Its language, particularly the clause granting immunity to unnamed potential co-conspirators, created confusion and hesitation. Prosecutors were reluctant to test its limits. Civil courts treated it as a complicating factor, even when it did not technically apply. This ambiguity worked in Epstein's favor. But cracks were forming. In 2016, a federal judge ruled that the handling of Epstein's original plea deal had violated the Crime Victims' Rights Act. The decision did not overturn the agreement, and it did not result in new criminal charges. But its symbolic impact was significant. For the first time, a federal court formally acknowledged that Epstein's victims have been excluded from the process. The ruling reframed the story. It was no longer just about a lenient sentence. It was about a failure of procedure, a failure of transparency, a failure of institutional responsibility. That shift mattered because it changed how journalists approached the case. Instead of asking whether Epstein had committed crimes, a question that had already been answered, reporters began asking why the system had protected him. Investigative journalists revisited old police reports. They re-examined plea negotiations. They compared Epstein's treatment to similar cases involving far less powerful defendants. Patterns emerged. The same prosecutors who had declined to pursue federal charges had later taken positions in elite law firms. Communications between Epstein's legal team and government officials revealed an unusual level of cooperation. Decisions that should have triggered scrutiny were treated as routine. By 2017, major news organizations were paying closer attention. Reporters at outlets with the resources to pursue long investigations began interviewing victims who had never spoken publicly. They obtained previously sealed documents. They cross-referenced flight logs with witness accounts. What they found contradicted the idea that Epstein's crimes were isolated or minor. They uncovered evidence suggesting a long-running pattern of abuse facilitated by money, staff, and logistical planning. The image of Epstein as a lone offender became increasingly untenable. Still, no criminal charges followed. This delay is critical to understanding what came next. The justice system did not suddenly awaken. It responded gradually, under pressure, as public attention intensified. In late 2018, that pressure reached a turning point. A series of investigative reports brought Epstein's history back in a national focus. The stories did not rely on new allegations alone. They reconstructed the entire timeline, from the early complaints to the secret plea deal to the years of freedom that followed. The narrative was no longer fragmented. It was cohesive. For the first time, the public saw the case not as a scandal that had ended, but as one that had been deliberately contained. Epstein's reaction to this renewed attention was consistent with his past behavior. He denied wrongdoing. He relied on attorneys. He projected confidence. There was no visible indication that he believed his legal position was vulnerable. But the environment had changed. Public tolerance for institutional silence was lower. Media scrutiny was sharper. And prosecutors, now under scrutiny themselves, faced questions they could no longer deflect easily. The decade of obscurity was ending. What followed in 2019 would not have been possible without this slow accumulation of pressure, built through civil litigation, judicial rulings, and investigative journalism. Epstein's apparent invincibility had not collapsed suddenly. It had eroded. By the beginning of 2019, the Epstein case had reached a point of no return. What had once been a contained scandal, managed through secrecy, settlements, and legal insulation, was now under sustained public scrutiny. The narrative had changed, and with it, the pressure on institutions that had previously looked away. This time, the attention did not fade. Investigative reporting had reconstructed the entire history of Epstein's crimes, exposing not only what he had done, but how the system had repeatedly failed to stop him. The question was no longer whether new evidence existed. It was whether prosecutors could continue to justify an action. In July 2019, that question was answered. Federal authorities in New York arrested Jeffrey Epstein on charges of sex trafficking of minors. The indictment alleged that Epstein had recruited, abused, and exploited dozens of underage girls between 2002 and 2005, primarily in New York and Florida. The scope of the charges was significant. Unlike the 2008 case, this prosecution was federal and aggressive. It reframed Epstein not as a man involved in isolated misconduct, but as the central figure in a coordinated trafficking operation. The language of the indictment emphasized pattern, organization, and intent. For For the first time, Epstein faced the possibility of real consequences. The arrest sent shockwaves through media, politics, and elite social circles. Epstein had been publicly visible for years, but few believed he would ever be charged again. The idea that he was untouchable had become deeply ingrained. That illusion collapsed in a single morning. Epstein was arrested at a private airport in New Jersey after landing on his jet from Paris. The image was symbolic, a man accustomed to unrestricted movement now in federal custody. Within hours, details of the indictment were public. Prosecutors announced that Epstein faced decades in prison if convicted. Bail was immediately contested, with federal attorneys arguing that Epstein posed both a flight risk and a danger to the community. They were explicit. Epstein's wealth, international connections, and history of influencing outcomes made him uniquely capable of evading justice. His past behavior, they argued, demonstrated a pattern of manipulation and exploitation that could not be ignored. Epstein's defense team responded with familiar strategies. They emphasized his prior conviction. They referenced the non-prosecution agreement. They argued that the charges amounted to double jeopardy. This time, the arguments failed. A federal judge denied Epstein bail, ordering him held without release. The decision marked a clear departure from how the system had treated him in the past. For the first time, Epstein was confined without privilege. He was placed in the Metropolitan Correctional Center in Manhattan, a federal detention facility designed for high-risk inmates. His conditions were restrictive. His movements were monitored. His communications were limited. This shift was not just procedural, it was psychological. Epstein was no longer operating from a position of control. He could not delay proceedings indefinitely. He could not negotiate quietly behind closed doors. The case was now unfolding in full public view. As details emerged, the scale of the allegations became clearer. Prosecutors described a system in which Epstein recruited young girls, often under the guise of offering money or mentorship, then subjected them to sexual abuse. These victims were allegedly encouraged to recruit others, creating a cycle of exploitation. The indictment referenced dozens of victims. Many of these women had never been included in previous legal actions. Their stories had not been heard in court. Now, they formed the foundation of the case. Public reaction was intense. Media coverage was relentless. Epstein's name dominated headlines. Old photographs resurfaced. His connections to powerful individuals were re-examined. Questions that had lingered for years were now asked openly. How had this man avoided accountability for so long? Who had protected him? And who else had been involved? These questions extended beyond Epstein himself. Prosecutors made it clear that the investigation was ongoing. They encouraged potential victims to come forward. They emphasized that the case was not limited to one individual. This language signaled a possible expansion. At the same time, Epstein's legal team began preparing for trial. They filed motions. They challenged evidence. They sought to limit the scope of testimony. The defense strategy was aggressive, but the environment had changed. Every move was scrutinized. Epstein's wealth, once an advantage, now fueled suspicion. His connections, once protective, became liabilities. The narrative of impunity that had surrounded him for decades was unraveling. Inside the detention center, Epstein's situation grew increasingly unstable. Reports surfaced that he had been placed on suicide watch after being found injured in his cell. The incident raised immediate concerns about safety, oversight, and institutional preparedness. Officials offered limited explanations. Speculation spread rapidly. The case was no longer just about prosecution. It was about whether the system could even keep Epstein alive long enough to face trial. This moment marked a critical turning point. The collapse of Epstein's legal shield did not bring clarity. It introduced new uncertainty. Trust in institutions already strained was now under pressure from every direction. Epstein had finally been arrested, but accountability was still not guaranteed. After Jeffrey Epstein was denied bail and placed in federal custody, the case entered its most fragile and consequential phase. For the first time in decades, Epstein was completely removed from the environment that had protected him. Private residences, elite networks, and legal maneuvering conducted from a position of strength. Inside the Metropolitan Correctional Center in Manhattan, Epstein was no longer insulated. The facility was designed to hold inmates awaiting trial in high-profile federal cases. Conditions were restrictive. Cells were small. Surveillance was constant in theory, but uneven in practice. Staffing shortages were common. Oversight was strained. From the beginning, concerns about Epstein's safety were raised. Federal prosecutors had argued that Epstein posed a risk, not only to others, but potentially to himself. Given the severity of the charges and the collapse of his legal defenses, the psychological pressure was obvious. In late July 2019, reports emerged that Epstein had been found injured in his cell with marks on his neck. Authorities initially described the incident as a suicide attempt. Epstein's attorneys disputed this characterization, suggesting possible assault. The lack of clarity fueled immediate suspicion. Epstein was placed on suicide watch, a status that involved heightened monitoring and isolation. He was moved to a special housing unit and assigned a cellmate. Under standard procedures, this classification should have ensured continuous observation. But it did not last. Within days, Epstein was removed from suicide watch. He returned to a regular housing unit. His cellmate was transferred. Monitoring protocols were relaxed. These decisions would later become central to public outrage. On August 10, 2019, Jeffrey Epstein was found unresponsive in his cell. He was pronounced dead shortly afterward. The official cause of death was ruled a suicide by hanging. The news broke rapidly and detonated public trust. The reaction was immediate and global. Epstein had been one of the most closely watched detainees in the federal system. His death occurred before trial, before testimony, before any public accounting of his actions or his network. For many, it felt like the final failure. Questions surfaced instantly. Why had Epstein been taken off suicide watch so quickly? Why had his cellmate been removed? Why were guards reportedly asleep or absent during required checks? Why did surveillance cameras malfunction at critical moments? Each question pointed toward systemic breakdown, not coincidence. The Department of Justice launched investigations into the circumstances surrounding Epstein's death. Internal reviews revealed severe lapses in protocol. Staffing shortages had gone unaddressed. Required checks were missed. Records were falsified. 2 correctional officers were later charged with falsifying records related to their supervision of Epstein. They eventually entered deferred prosecution agreements, avoiding prison time. To the public, this resolution felt inadequate. Epstein's death ensured that there would be no criminal trial, no cross-examination, no discovery process that could force disclosure of associates, enablers, or beneficiaries. Epstein was placed on suicide watch, a status that involved heightened monitoring and isolation. He was moved to a special housing unit and assigned a cellmate. Under standard procedures, this classification should have ensured continuous observation. But it did not last. Within days, Epstein was removed from suicide watch. He returned to a regular housing unit. His cellmate was transferred. Monitoring protocols were relaxed. These decisions would later become central to public outrage. On August 10, 2019, Jeffrey Epstein was found unresponsive in his cell. He was pronounced dead shortly afterward. The official cause of death was ruled a suicide by hanging. The news broke rapidly and detonated public trust. The reaction was immediate and global. Epstein had been one of the most closely watched detainees in the federal system. His death occurred before trial, before testimony, before any public accounting of his actions or his network. For many, it felt like the final failure. Questions surfaced instantly. Why had Epstein been taken off suicide watch so quickly? Why had his cellmate been removed? Why were guards reportedly asleep or absent during required checks? Why did surveillance cameras malfunction at critical moments? Each question pointed toward systemic breakdown, not coincidence. The Department of Justice launched investigations into the circumstances surrounding Epstein's death. Internal reviews revealed severe lapses in protocol. Staffing shortages had gone unaddressed. Required checks were missed. Records were falsified. 2 correctional officers were later charged with falsifying records related to their supervision of Epstein. They eventually entered deferred prosecution agreements, avoiding prison time. To the public, this resolution felt inadequate. Epstein's death ensured that there would be no criminal trial, no cross-examination, no discovery process that could force disclosure of associates, enablers, or beneficiaries. The central figure was gone, and with him, the possibility of full accountability. This vacuum fueled speculation. Conspiracy theories spread rapidly, amplified by the unprecedented nature of the failure. Some believed Epstein had been silenced to protect powerful individuals. Others argued that incompetence alone was responsible. The truth, as often happens, was likely less cinematic and more disturbing. The system failed at every level. It failed to protect victims. It failed to prosecute effectively. And in the end, it failed to preserve the integrity of its own process. What followed Epstein's death was not closure, but fragmentation. Civil lawsuits continued. Victims pursued claims against Epstein's estate. Ghislaine Maxwell, once operating quietly in the background, became the focus of renewed attention. In 2020, she would be arrested and later convicted for her role in facilitating Epstein's abuse. But even that outcome could not fully resolve what had been lost. Epstein's death eliminated the possibility of testimony that could have clarified the extent of his network. It prevented direct confrontation between victims and the man who had abused them. It denied the public a transparent legal reckoning. In the months after his death, institutions issued statements. Reforms were proposed. Reviews were conducted. But trust, once broken, was not easily restored. The Epstein case became a symbol, not just of personal criminality, but of institutional failure. It illustrated how power distorts accountability, how secrecy corrodes justice, and how systems designed to protect can instead enable harm. Even after his death, Epstein continued to shape public discourse. His name became shorthand for elite impunity. His case was cited in debates about criminal justice reform, prosecutorial discretion, and victims' rights. But for those most affected, the story never became abstract. For the victims, Epstein's death was not an ending. It was another denial of answers, of validation, of the chance to be heard in full view of the world. The case closed without resolution, and that perhaps is its most enduring legacy.